Chief Justice, may it please the Court, my name is Paul Mazan. I represent the petitioner, Mr. Lester Freeman, with my co-counsel, Ms. Jade Wallace. I will be addressing the prior restraint issue, and Ms. Wallace will be addressing the Espionage Act charge. Before I begin, may the petitioner reserve 1 minute for rebuttal, and would the Court like a brief statement of the facts. This Court should reverse the Fourth Circuit Court of Appeals decision that held the District Court's protective order as constitutional for the following 3 reasons. First, the government fails to demonstrate that publication will surely result in direct, immediate, and irreparable harm to the nation. Second, the government fails to show that whatever harm could result from publication outweighs the costs of invading Mr. Freeman's First Amendment rights. And third, the District Court's protective order is unconstitutionally broad. Your Honors, this Court has never affirmed a prior restraint on national security grounds. However, it has identified certain minimal conditions that must be met before the prior restraint can be imposed. In New York Times v. United States, Justice Stewart stated that to impose a prior restraint on national security grounds, the government must demonstrate that publication will surely result in direct, immediate, and irreparable harm to the nation or its people. Similarly, Justice Brennan, in his concurrence, stated that the First Amendment tolerates absolutely no prior judicial restraints of the press predicated upon surmise or conjecture that some untoward consequence may result. Here, as in the Pentagon Papers case, the alleged harm to the nation is speculative and cannot justify the imposition of a prior restraint. On page 26 of the record, the government claims that if the documents are published, American troops will be killed. The government fails, however, to sufficiently demonstrate how or why the publication of documents that are nearly 4 months old will surely result in direct, immediate, and irreparable harm. On page 30 of the record, the government argues that publication will cause the deaths of American troops because Mr. Freeman's previous publication of completely different information had that tragic effect. But simply because something has happened in the past does not mean that will necessarily happen again in the future. In Neer v. Minnesota ex rel. Olson, this court held that a system of prior restraints that imposed injunctions on newspapers that had a history of publishing defamatory information was unconstitutional. It reasoned that an individual or media organization could not lose its right to speak without prior restraint simply by exercising that right. Applied to this case, Mr. Freeman's speech cannot be restrained merely on the grounds that his previous speech had the unfortunate effect of contributing to the deaths of American soldiers abroad. Moreover, the circumstances now are drastically different than they were when Mr. Freeman made his first publication. When Mr. Freeman made his initial post, the military was completely unaware that Captain Daniels had compromised the information. Since then, the military has had over 4 months to prepare for the release of these documents and has almost certainly revised its plans. Considering that the government concedes on page 8 of the record that it has no idea who else besides Mr. Freeman possesses this information. Whatever speculative harm might result from the release of this 4-month-old information, it certainly does not outweigh the harm of restraining Mr. Freeman's speech. Which brings me to the second reason that this prior restraint is unconstitutional. The value of Mr. Freeman's speech far outweighs the dangers of publishing it. In Landmark Communications, Inc. v. Virginia, this court stated that in cases involving restrictions on free speech rights, the harm of the speech must be balanced against the need for free and unfettered expression. In this case, the need for free and unfettered expression is essential for a number of reasons. First, Mr. Freeman's speech pertains to important current events. In Nebraska Press Association versus Stewart, this court stated that prior restraints that restrict speech communicating news and commentary on current events are especially frowned upon. Here, Mr. Freeman's speech involves just that: news pertaining to current events, the war on terror, the war on Afghanistan. If the public does not know what our government is doing overseas, it will have no way to determine or dictate what the United States should do overseas. Second, Mr. Freeman's speech is too valuable to be restrained because it reveals evidence of government misconduct. In Neer versus Minnesota, this court stated that the First Amendment was especially important because of the immunity it afforded to the publication of news exposing government wrongdoing. Mr. Freeman's speech involves just that: evidence that the United States military is conducting operations in direct violation of United States and international law. And Mr. Freeman's speech doesn't reveal a trivial offense or mistake by the military that the public need not immediately know. The documents in Freeman's possessions don't show that the United States military has unpaid Afghani parking tickets. The documents reveal that the military was developing and deploying chemical dirty bombs in direct violation of the Chemical Weapons Convention. This is undisputed. On page 37 of the record, the Court of Appeals stated that the military's plans constituted an obvious violation of this very serious international law. And the specific terms of this law, to which the United States is a long-time signatory, underscore the importance of Mr. Freeman's speech. The convention categorically bans the first use of chemical weapons in warfare, but permits retaliatory use. If the United States were to successfully carry out a mission like Ride of the Valkyries, which Mr. Freeman exposed, and detonate chemical dirty bombs in Afghanistan, then Taliban insurgents could lawfully use those same weapons against us. In a system of self-governance such as ours, the public must understand this to engage in informed debate. But should this court find that there are grounds for a protective order, the protective order issued in this case is still unconstitutional, which leads me to the petitioner's final point. The protective order is unconstitutionally broad. In Carroll versus President and Commissioners of Princess Anne, this court held that an order issued in the area of protective rights must be couched in the narrowest terms that will accomplish its pinpointed objective. Here, the protective order restricts far more speech than necessary. On page 32 of the record, the district court admits that several of the deployment orders at issue have been executed or are now out of date. Similarly, on page 49 of the record, the Court of Appeals recognized the broad reach of this protective order. But neither the district court nor the Court of Appeals explain why this protective order needed to be so broad. There were several alternatives available to the district court that could have narrowed the scope of this prior restraint. First, the district court could have allowed the release of documents that are stale and out of date. The specific movements, numbers, and locations of troops involved in operations that have already taken place present no threat of direct, immediate, or irreparable harm to the nation. Second, the district court could have redacted the numbers, locations, and movements of American soldiers so that just the evidence of government wrongdoing could be published. Or the district court could have made the protective order temporary instead of indefinite, giving the military time to adjust its plans so that no troops would be at risk if the documents were released. Your Honors, for these reasons, the protective order restrains far more speech than is necessary and is unconstitutionally broad. Your Honors, in closing, I would like to point out this fact. The government seeks to infringe upon Mr. Freeman's First Amendment rights in the name of national security. But securing the nation means more than just securing the safety of our troops that are fighting abroad. Securing the nation also means securing the rights that make this nation worth fighting for. Ultimately, for this reason and the foregoing, Petitioner asks that this court reverse the Fourth Circuit Court of Appeals and hold that the district court's protective order is an unconstitutional prior restraint on speech. Thank you.